Welcome to the Fearless Floyd Show. We'll begin in 40 seconds. Hello, everyone. Welcome to the Fearless Floyd Show. As always, I am your host, Fearless Floyd. And man, I just got this CD-ROM from the Texas Court of Criminal Appeals containing all my filings in that court. So I uploaded everything into my external drive and kind of opened up a few of them. And I tell you what, you talk about bringing back some traumatizing memories. Oh, man. Traumatizing places. So instead of going through all that, sitting here by my lonesome, I've always told you folks that my litigation, when I was incarcerated, is just off the frickin' charts. And I'm going to show you just how off the charts it actually was. Because remember, all this was created using a typewriter, an electric typewriter. And, that's just the most basic, cheapest typewriter on the market. At the time, they had some Smith Coronas. And they quit selling those and they started buying Olympus. And then the Chinese trade thing took over. And, everything that you buy now is made in China. And they started buying units made in China that were knockoffs of the Olympus. And they were just garbage. They lasted a year. If you bought one, you were going to have to replace it in a year. If you got 2 years out of it, you were lucky. But if you were extremely prolific, utilizing a typewriter daily, sometimes 16, 17, 18 hours a day straight, save going to the shower, going to eat breakfast, lunch, and dinner. If I went to those, I didn't just eat in the house, slam a soup. So you're going to see some of this. Now, the writ of habeas corpus that you're going to see filed on this particular DWI that I'm discussing, it took me 3.5 months to put that together. Okay, that's to type it. Just to type it. 3.5 months of all day, every day, all evening, as late as I could go. Rack time, 1 o'clock on the weekends if my cellie wasn't in the house. Even if they were in the house, some of them didn't give a shit. So, yes, I did hear about Charlie Kirk. I'm watching it over here on Fox as I speak. Usually I watch my own show. Expect more of this. More and more and more and more and more. They want an internal civil war. I keep telling you all this. That, they love wars. Nothing better than have one internally. That way we don't have to send any money anywhere. We just keep it all internal. But that's not what we're talking about here. We're going to go review my DWI. That thing. So I've got to pull it up and it's over in another window. right, so what I'm going to have to do is go open it up. Okay, there it is. Yeah, that light is blinding me. All right, I can never go back when I do that. That sucks. All right, let me take myself out of the picture. And we're going to go down this list. And this is by filing. And the date is just when they reviewed it. And let me get over to that window, wherever it is. All right. So I actually, this is the remand back to the Court of Criminal Appeals for, I have to go through this to get back to this. This was just on top. It was an opinion and it had number 1 in parentheses. So I thought it might have been a duplicate of this one, but it wasn't. So I opened it up to see if it was a duplicate, and it wasn't. And so I just went ahead and renamed it for simplicity's sake. But you can go back, and if you see this number right here, the WR-17, 817, then it goes -01. But the 17817, that is my personal writ file at the Court of Criminal Appeals. So every time I file a writ, all they do is just add a hyphen and whatever number it is. So here's number 11, just to show you the veracity and volume. So all the way to number 11. And we're going to get into all of these. I've gone to, I skipped around a little bit. But 04 and 05. So in between 04 and I may open these up, but it should be 10. It was, yeah, Fun City. Multiple civil rights and civil RICOs were filed all during this. So we're going to open up, take a look at some of this stuff. Let's just open up the remand real quick. Let me make sure that my screen shared. It did not. And I hate that little quirk with StreamYard. All right, I've shown you all the actual print out of this one. I'm on a live. Can I call you back? Okay, bye. All right, it's an order, and it was what was that? You see, it's done per curiam, so nobody took responsibility for doing it, and it's from August 19th, 2009. Okay, 2009. Take note of that date right there. So, order. Pursuant to the provisions of Article 1107 of the Texas Code of Criminal Procedure, the clerk of the trial court transmitted to this court this application for writ of habeas corpus, ex parte Young, 48, blah, blah. Applicant was convicted of driving while intoxicated and sentenced to 60 years imprisonment The First Court of Appeals affirmed his conviction, Tarvin versus State. The applicant contends, among other things, that his trial counsel rendered ineffective assistance of counsel on September 18th, 2006. Okay. The trial court signed an order designating issues, but no finding of fact and conclusions of law were forwarded to this court. Okay. You see that 4-year gap between, August 19th to September 18th, 2006. So 3-year gap. Let me explain to you what the law says. Okay. They have 35 days. That's what the clerk has, 35 days. State has 15 days to reply to your writ. The court has an additional 20 days to act. If they don't act within that 20 days, the court is the clerk of the court, which is the district clerk. At the time was Charles Baccaris. Then it went to Teresa Chang, Lauren Jackson. I went through a whole bunch of them. I sued all of them. Why? Well, it wouldn't happen to be the documents filed into the district clerk's office were often found on shelves, stuffed in drawers, in places other than the file in which they belonged, and some were file stamped and some weren't. And I'm paraphrasing, but that's almost word for word. So for those 3 years, the clerk was in violation of my constitutional rights. 3 years I fought these low-life, degenerate, evil, satanic, in my opinion, government officials. Absolutely. So, applicant has alleged facts that, if true, might entitle him to relief, and that's Strickland versus Washington, Ex parte, Lemke. In these circumstances, additional facts are needed. As we held in Ex parte Rodriguez, which is the standard for ineffective assistance of counsel in its adoption of the Supreme Court case Strickland versus Washington, the trial court is the appropriate forum for findings of fact. The trial court shall provide applicants' trial counsel with opportunity to respond to applicants' claims of ineffective assistance of counsel. The trial court may use any means set out in the Texas Code of Criminal Procedure, Article 1107, Section 3D. In the appropriate case, the trial court may rely on its personal recollection. Well, since the judge, Mark Kent Ellis, who was the elected presiding judge, did not conduct phase 1 of the 2-phase bifurcated trial, the guilt and innocence phase. He was not there for the testimony. He was trying the South Park Mexicans case in another courtroom at the same time as my trial was proceeding. So he doesn't know jack shit. If the trial court elects to hold a hearing, it shall determine whether applicant is indigent. If applicant is indigent and wishes to be represented by counsel, the trial court shall appoint an attorney to represent him at the hearing. Texas Code of Criminal Procedure, Article 26.04. What do you think when I saw that? Ding, 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 ding. Petition for writ of habeas corpus ad testificandum. Oh, yeah. Give me a bench warrant and bring me back to the trial court for this evidentiary hearing. Absolutely. Trial court shall make a findings of fact as to whether the performance of trial counsel was deficient, and if so, whether counsel's deficient performance prejudiced applicant. The trial court shall also make any other findings of fact, conclusions of law that it deems relevant and appropriate to the disposition of applicant's claims for habeas corpus relief. This application will be held in abeyance until the trial court has resolved the fact issues. The issues shall be resolved within 90 days of this order. If any continuances are granted, a copy of the order granting the continuance shall be sent to this court. A supplemental transcript containing all affidavits and interrogatories or the transcription of the court reporter's notes from any hearing or deposition, along with the trial court supplemental findings of fact, conclusions of law, shall be returned to this court within 120 days of the date of this order. Any extensions of time shall be obtained from this court. Well, you bet I didn't. You bet. About this time last year, this time in 2009 at the John M. Wynn unit, I'm jumping up and down. I'm ecstatic. I can't freaking wait to get back into court, because by 2009, I'm battle worn, seasoned veteran, survivor, been through everything these evil, satanic governmental officials could have put me through. So I'm ready. I'm hardened. I'm like, can't wait. So it's actually a good thing that I showed you this first, because it shows the pattern of what these folks did to me. And I'm not the lone person that, oh yeah, we're going to target Floyd. He knows too much. He's too smart, or he's filing too much shit, or he's got too many lawsuits pending. And no, he knows where the skeletons are buried. Yep. Article 3, Clause 2 of the Constitution, anytime the state is party to an action, the Supreme Court has original jurisdiction. Well, if we could get the courts to follow the law, and we could get the government officials to follow the law, actually know the law, most of them have no clue. Because I guarantee you, okay, you could call any government official right now, I don't care what level they're on in the state of Texas, and ask them, can you tell me what 800 new laws went into effect September 1st, 2025? How about 10? You can't name 10 of 800? Why not? You're supposed to know the law, right? This is how absurd society has allowed itself to get. I mean, it's insane. I mean, this is like demented criminal activity. It's just, it's bizarre. That's what I can tell you. And I'm going to go down here. We're going to go through all the proof, and I'm going to show you the evil, satanic wickedness of these government officials, how they act, how they don't follow the law. They don't care about the law. They don't even want to correct it. Even when potentially innocent people have been put to death on death row. Absolutely. And this isn't bullshit, folks. I'm giving it to you in black and white. This is their stuff. Okay. I don't make shit up. You hear me tell stories, but you know what? I always come back and back up those stories with black and white, don't I? Always. I've been telling you about the whole district clerk thing when the judge admitted that stuff filed into the clerk's office but it wasn't in the file it was supposed to be in. How they held my writ of habeas corpus on my misdemeanor DWI for almost a year before they sent it to the Court of Criminal Appeals. My other one, they held 3 years. And it was a long, and I'm going to show you how long it took me to fight to get to there. Listen, none of these folks play fair. They don't follow their own rules, their own procedure, laws. They don't give a fuck about the Constitution in the state of Texas. Period. They have splintered that thing up. They have redefined the words of the founding fathers of the state of Texas. Absolutely, they have. Yeah. Evidence? Nah. Testimony. Yeah, it covers everything. No such thing as physical evidence, according to the Texas Supreme Court Court of Criminal Appeals. Otherwise, you could not be compelled to give evidence against yourself under Article 1, Section 10 of the Texas Constitution. There it is. But they splintered that. They redefined the word evidence, and they failed to go back and actually look at the framers' intent. All you got to do is go St. Mary's Law Review and read the law review on Article 1, Section 10. Go look it up. St. Mary's Law Review, San Antonio, Texas. Absolutely. St. Mary's College of Law. Go look it up. Go read it. Go read. It's fundamental. See, and this is what they don't do because they don't care. Because it's all about the legal system justifying its existence by creating more bullshit for you to wade through. The need for more attorneys. And thank God AI is here for that. So all you attorneys out there who've been just grifting and scraping and fucking people over and, selling out one client for two over here with this deal and that deal. Yeah. Yeah. Karma's a bitch. See you in the unemployment line. Oh, how can they charge you with a DW? That's a fantastic question. Would you like the answer? This is the answer. Okay. This is the answer. If you have a key fob or the keys that can operate that vehicle and you're in the vehicle, they can give you a DWI for that. I've seen it. Okay. They'll go so far as to somebody who knew they were intoxicated, knew they were impaired for whatever reason. Let's just say they ate too many prescription drugs. Okay. Or maybe some over the counter, or maybe they just weren't feeling well. And they put the keys to the ignition and turned it back to accessory to maybe listen to the radio, turn on the fan. That's operating a vehicle in a public place. I actually had a cellie who got 2 DWIs a month apart for doing exactly that in the same parking lot of the same bar. Absolutely. Too drunk, got in, put the keys in the ignition, turned it back, fell asleep, boom, DWI. He wasn't even driving. He was sleeping. And then he did it again a month later. But that guy, he had, I think, 8 or 9 DWIs. He was one of those, where they just kept, get the fuck out of here. 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 You're not dangerous enough until you're too dangerous, right? So that's how they can charge you. Now, in my case, hey, brother, I'm doing a live. Can I call you back? In Texas, okay, there's multitudes of ways that you can be convicted of a DWI. You can have a blood alcohol content of 0.08 or greater, right? You can have other adulterating substance now that they use the blood test to go find, which could be some type of prescription drug, illegal drug, even an over-the-counter drug. Yes. Okay. So it's just introduction of an intoxicating or an adulterating substance that caused you to lose your mental and or physical faculties by the induction of that particular substance. So mental, they ask you a question, you stumble, you don't get it. Or you're slurring your words and talking about tacos on Saturday morning, Sunday services. What? Or you just like fall right out of the car on the concrete. You're like, hey, I'm off like that. Now you lost your physical faculties, correct? So those are the 4 ways, but 3 that they can convict you. So in my case, My attorney strategy was we're going to challenge that I did not have a .08 or greater BAC, even though there were no standardized field sobriety tests at the scene. Refused, refused, refused. Breath test? Nope. Refused. Okay, blood test. Nope. Refused. Well, oh, they didn't even charge me for having a .08 BAC or greater. They charged me with having lost my mental or physical faculties. So my attorney challenged something that didn't even need to be challenged because it didn't exist. His trial strategy was completely inaccurate. I know. Could it get any worse? Oh, absolutely. I haven't even got to the record yet. I'm just telling you the story. My attorney, my trial attorney, he's been disbarred. Whole lengthy shit show of that. So that's how they can get you for a DWI. Yeah. Listen, I'm not here to support drunk driving because I think it's a abhorrent thing to do, especially in this day and age when it's so easy to get transportation. I don't think anybody should be driving impaired for any reason. Just not this day and age. Hopefully one day we'll get, these taxis and yeah, you can stumble in one of those and they just, give you your ride home for whatever flat fee, $5. That sure is cheaper than 50,000. That's about what it eventually will cost you. So anyway, it's a shit show all the way through. So let me get back over here to the share screen. Still remand. Nope. All right. This one is from way, 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 way back. I think this is 1980. This one's for the quarter pound of cocaine, I'm pretty sure. Yep. Quarter pound of cocaine. I sold a quarter pound of cocaine rock. One rock to an undercover narcotics agent. Lucky me. Right. That's what happens when you trust relatives of your friends who can't hold their own. But that's a whole nother story. Okay, let me get back on track. All right. So without that one, I don't know where 2 is. Why there isn't a 2. I don't know what 3's on, but we're going to go find out. I didn't even think I looked. Oh, here we go. DWI. Returning the application because it does not comply with Rule 73.2. So that's my trial court number. I'll eventually have a B right here. None of these folks still are on the Court of Criminal Appeals anymore. Actually, all these names have changed. So that's the writ. Let's see what else we have here for 03. Generic Vegas cuts mine. It's not been received by this court. Case is this? United States Supreme Court. Okay, this is my writ of certiorari to the United States Supreme Court on my DWI. Oh, from my direct appeal, rather. All right, these are just like one-pagers. So that's all of 3. So let's open up 4. I'm going to stop share just to make sure that I am sharing. Did I ever try to get in the federal court? Of course. I'm published in the United States Supreme Court, and I don't even know what my federal publications look like. Absolutely. All right, as you see, this is 04. It was scanned 2008, almost 2009. Okay, this one is me dealing with my misdemeanor DWI. Now, how this works here in Texas, they can use 2 prior DWI convictions to enhance your new DWI to a 3rd-degree felony. So if you can prevent them from using one of the prior DWIs, it just knocks it down to a misdemeanor. In my case, because I was a habitual idiot, habitual felony offender, punishment got double whammied on me. I told you, it gets worse. So what they did is they enhanced the offense from a misdemeanor to a 3rd-degree felony, and then used 2 prior felonies to use the 3rd degree to enhance me to a habitual felony offender, 25 to 99 or life. But I decided to take it to trial, so I was challenging one of these misdemeanors, and this is the case in which I had a $1 million appeal bond that was eventually lowered after about, 2 years of back and forth. And I don't even know what this is all about. Yeah, I'm trying to get records of something. Got it eventually lowered to $250,000. I know, what a bargain, huh? I got whipped out my credit card and I was like all over that. Not. All right. Miscellaneous document received. Original writ of mandamus. Pending disposition, return, and appeal of motions and cause number 8817-16-B. I don't know why these are over here. So I'm talking about B. This is A. Okay, these are, yeah, I remember asking for all these. So this is what I'm asking for. These were filed in February 2006. Motion to proceed pro se by self-representation in all proceedings. He granted that. Motion for the trial court's reporter stenography and electronically record all proceedings. Granted. Motion for funding to hire independent expert witness, denied. Appealed. I did an interlocutory appeal. Motion for funding to hire independent private investigator, denied. Notice of appeal. Motion for production and transmission of records and evidence, denied. Appealed. Motion for bond setting and or personal recognizance bond release, denied. Appealed. Motion for new trial in Harris County Criminal Court at law of misdemeanor jurisdiction, denied. Appealed. Motion to vacate, set aside offense and conviction, denied. Appealed. Motion for production of petitioner to attend all proceedings, denied. Appealed. Motion requesting a subpoena ducis tecum to produce documents, denied. Appealed. Motion to recuse the Honorable Judge Mark Kent Ellis from all proceedings in this cause due to judicial bias, pending. The following motions were filed March 15, 2006, with oral arguments requested. Petition for live testimonial hearings in all matters and proceedings, that no paper hearings be held in all matters and proceedings, pending. The reason I did this is because they have what they call paper hearings, where they'll just send a letter, like the judge or the court will send a letter to the to my trial attorney and say, okay, here, we need your answer why you were or were not ineffective as claims made by the petitioner. And they'll file an affidavit. Oh, I wasn't, I didn't provide an effective assistance and blah this, blah that. And that's it. That's a wrap. That's the hearing. And they call those paper hearings. So I'm trying to prevent Harris County from having a paper hearing and not have me present to represent myself at all hearings like it's required by the Constitution. Petition for disclosure of his grand jury minutes, pending. Motion requesting designation of all 95 grounds of error presented in his application, pending. Motion to challenge the felony jurisdictional authority of the 351st Judicial District Court of Harris County, Texas, over the petitioner's offense and his conviction as charged in the indictment, pending. Motion for transcription production of prior motion hearing minutes provided to the petitioner, pending. Petition for commencement of a court of inquiry to be authorized and established to determine whether an offense has been committed against the laws of the state of Texas, pending. The following motions were filed on March 22, 2006, with oral arguments requested. Motion for appointment of special master, pending. Motion to set aside his 60-year sentence, pending. Motion to strike Houston Police Department Officer Russell W. Rudy's testimony from the record due to perjury by Rudy, pending. Motion to strike Houston Police Department Officer Christopher Green's testimony from the record due to perjury by Green, pending. Motion for IQ test and psychological test evaluation, pending. And that's not for me, believe it. That's Floyd digging into the statutes. Motion to determine jurisdictional authority over the petitioner's offense of a felony DWI, pending. Motion to disqualify and render void all acts and authority of senior retired Judge Larry L. Fuller. He was my visiting judge that sat over the phase one of the two-phase bifurcated trial, the guilt and innocence phase and sentencing phase. Judge Ellis was trying the South Park Mexican, as I said earlier, and handing out 45 years aggravated for aggravated sexual assault of a child of his wife that he married. And they just happen to be from Mexico. And you know how the Mexicans are. They just have a whole different age range, don't they? And 25, motion to dismiss indictments as invalid and void. What the hell is that? Okay. Hang on 1 second. Okay, got that taken care of. I forgot I changed the notification bell. All right, motion to dismiss indictments as invalid and void pending. These motions were filed on April 14th, 2006, with oral arguments requested. Motion to poll jury members to determine whether petitioner had lost his mental and or physical faculties to find guilt by unanimous verdict. Petitioners, like I said, I've forgotten more law than most people will practice their entire careers. Petitioners' notice of appeal of motion denials filed March 15th, no appellate court assignment, no appellate case numbers, no disposition. Appellant's brief filed on March 15, 2006, no appellate court assignment, no appellate case number, no disposition. Please forward petitioner's copies, blah, 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 blah. And here's everybody who got copies. I don't know if y'all can see this. Let me stop sharing just to make sure that we are sharing. We're all on the same page, Floyd. Which one am I at? Oh, no, it's not the one I want. There we go. So you see how many motions that I have filed in just like this little short time. So that was from 2006, and that's one they labeled 04. And don't ask me if they have this in, the correct order. That was 04, document received, writ received. What is this? Copy request. Did we look at this one already? Yeah, we looked at that one. Kill some of these before I get 1,000 tabs open. All right. And writ received. What is this? Writ of mandamus. Application for we got denied. Yeah. I got to show you all this. All right. I mean, I can't do anything but laugh now, All I can do. These people are sick. It's when you see this, you're gonna like, yeah, these people are sick. Okay. Scanned April 13th, 2006. So it was sent January 25th, 2006. So it took them, quite a while just to scan it. And it was filed February 1st. So they got it within a week. They had it file stamped. So motion for leave and petition for writ of mandamus, blah, 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 blah. And I don't know how many of these I filed. Well over a dozen. And you see, I did all this with a typewriter. And I used to get cute and make it all pretty and put little dots on it. And yeah. Wait till you see the ones where I actually change out the print wheels so it has different fonts. But yeah, I figured if I made it a little bit more catchy, stand out, I get noticed a little bit more. But here's my writ, jurisdiction. There's your table of appendices. just what? We're up at 76, 82 pages as exhibits. Ouch. So this was scanned the 13th. Here we go. Motion for leave to file petition for writ of mandamus. So motion for leave. So I'm asking for permission to file the petition for writ of mandamus to get relief, because that's a requirement. So you see who the respondent is. That Judge J. Carahan's court. Actually, apparently, according to one of my ex-girlfriends, she says she smoked pot with, that's almost a quote, with Jay Carahan. I was like, really? That makes sense. What am I trying to do? I think I'm trying to get them to act. Yeah. All right. This is what I explained to you, folks, that I've also gone round and round with our now mayor of Houston, John Whitmire, who used to be the chair of the Senate Criminal Justice Committee for the Texas legislature. Now, for someone challenging a felony conviction, you would use Article 1107, okay, as the procedure of what to do once the petition is filed. The authority governing the ability of one to challenge a felony conviction by way of writ of habeas corpus is Article 1108. 1109 gives you the authority to challenge a misdemeanor conviction. Well, you would naturally assume that, I guess, since 1107 is the procedure for 1108, that 1109 is the authority, that the 1110 maybe would be the procedure, or maybe it's 1106, but it's not. And actually, there is not a procedure to challenge. And when that occurs, pursuant to the law of the land, folks, okay, in every court, in all jurisprudence, the court must look to a similar or same statute and harmonize the two. So all they got to do is just go like, okay, we're just going to go up to 1107 and follow that procedure. That procedure, here you go. All right. That procedure requires the state has 15 days in which to respond to move its application of relief, which is July 28, 2005. That's following 1107 3B, to which the state failed to respond to the application and brief within the allotted 15 days. Then the court had 20 days from July 28, 2005, which to decide whether there are any controverted, previously unresolved facts material to the legality of Move-It's confinement. That's 3C. The Court of Criminal Appeals failed to take any action in regard to Move-It's filing an action and brief. And actually, they sat on it. And the judge decided he was going to create his own schedule of how the writ of habeas corpus would be adjudicated. And this goes on and on and on. And I kept going round and round and round, and nobody wanted to hear it. I mean, nobody wanted to hear it. John Whitmire didn't want to hear it. Senate Criminal Justice Committee didn't want to hear it. The clerk, Charles Baccaris, didn't want to hear it. Then Judge Jay Carahan didn't want to hear it. Court of Criminal Appeals didn't want to hear it. First Court of Appeals didn't want to hear it. Nobody wanted to hear it. And I fought and fought and fought and fought and fought and fought and typed up these just crazy writs, petitions, motions. Here it is, folks. Y'all want to find out who I am, what I'm all about, what I can really do? when I'm focused, this is it. Somebody ran out of typing ribbon. Either that or my typewriter broke. One of the two. So how long do you think it would take you to put all this together? Just this document. That's the application. Here's my grounds. And here's what I'm challenging. Petitioner was denied the right to jury trial under the Sixth Amendment of the U.S. Constitution. And of the Texas Constitution, petitioner never orally or in writing agreed to nor submitted a legal valid waiver to his right to jury trial. So if you go back and look on the judgment and sentence, there's nothing there because that's just how they did it back then. You know, that would be called a technicality or a loophole. But hey, guess what? It's there. And I know I'm right. And they were not trying to hear it. That's why they gave me a $1 million appeal bond on this particular case that we're looking at right here, which was eventually, oh yeah, see, here's where I start changing them up and getting all pretty. Isn't that pretty? Telling you I was insane. And this is when, okay, look how I have this table of or index of authorities. I have the Court of Appeals in Texas because there's 15 courts of appeals, Court of Criminal Appeals. So I've separated them from the lowest to the next highest up, all the way to the Supreme Court of Appeals. What the fuck I was thinking there. Codes, Texas criminal, Texas government, penal. And then when you have other publications, you just put them legal publications or other if you're going to cite them. But this one was a slam dunk. This is when I was really sick with it. Thought all this was going to make a difference. Oh no. The History of English Law. Commentaries on the Laws of England. William Blackstone. And here it is where I break it all down. Now, mind you, as I'm, doing all this at this particular time, I think I'm going home. I think I'm fixing to flip this thing. I already know there's a there. I already know that they failed to allege the commission date. I've got all the case law behind me, all the way to the United States Supreme Court. So I'm just trying to get back to Harris County because I know once I'm back in Harris County, that's a wrap. So the easiest thing you do is just go here and go to my prayers, read the heading and read the prayer. That's all you got to do. If you want everything to back it up, that's all in the middle. Here's everything to back everything up. Yep. Did my own findings of fact, conclusions of law, submitted that. Affidavit certifying exhibits and statements herein. More indictments. That's for my felony DWI. I'm just halfway through this, folks. Through this just one little filing. Halfway. Or no, I'm at the end now. Okay, I'm sorry. I got a little dot over here. There we go. All right, so we went through that one. And all right, so we went through that one. Where does 05 start? Okay, so it's backwards. So every time they got something, it's backwards. All right, what is this? Another mandamus? I can barely read this one. What I tell everybody to do, go to the prayer. Void all acts by the 351st Court after March 6th. Also prays the court determine that there are unresolved issues of fact and grant the petitioner all relief he so seeks in his Article 1107 writ habeas corpus application and supporting brief. Requested therein all 95 grounds of error and all things he so prays. So this is where we go round and round between me and the court. I'm not going to dive into that. So we're going in this vicious circle jerk for years, trying to get something done. And eventually I finally got them to do the order. Oh, no, that's not the one I want. Let me go over here. Let me scan through these real quick because I don't want to take y'all down just a bunch of writ of mandamus shit. Ex parte. Who's this from? Marquette Ellis, September 18th, 2006. Respondent's proposed order designating an issue. Having reviewed the application for writ habeas corpus, court finds that the following issues to be resolved: whether applicant's indictment was invalid or improperly amended, whether there was no evidence or insufficient evidence to support the applicant's guilt, whether there was prosecutorial misconduct and perjury in applicant's trial, whether there was double jeopardy violation in applicant's case, whether applicant was denied effective assistance of counsel at trial, whether there was trial counsel's error here. Let me show you all this. I want to read it. Right here. Let's see when it was scanned. And this is respondent's proposed order. So this would be from the state. You see it's file marked. The clerk of the court is ordered to transmit a copy of this order designating it issued to the Court of Criminal Appeals. The clerk of the court is ordered not to transmit at this time any other documents in the above style case to the Court of Criminal Appeals are ordered by this court. And see, he's way out of his timeline. Way beyond his little 20 days to act. And this is what I said. They do not follow their own rules and procedures. They do whatever the fuck they want. And then when you try to get some accountability out of them, they dismiss your case. And it looks like every time I sent them a letter, they, yeah, that's a letter. Another letter. Disposition. Yeah. Gotta show you. Here you go. Here's the 05, September 20th, 2006 order issued. Again, this is coming out of 351st. Original writ of mandamus in the Court of Criminal Appeals. Boom, there's the number versus the Harris County District Clerk. I told you I sued the shit out of these people. I mean, I don't know how many times. Per curiam, nobody's taking responsibility. Order. Relator has filed a motion for leave to file a writ of mandamus pursuant to the original jurisdiction of this court. In it, he contends that he filed an application for writ of habeas corpus in the 351st Judicial District Court of Harris County, that more than 35 days have elapsed and that the application has not yet been forwarded to this court. In these circumstances, additional facts are needed. The respondent, the district clerk of Harris County, is ordered to file a response, which may be made by submitting the record on such habeas corpus application, submitting a copy of a timely filed order which designate issues to be investigated, by stating that the nature of the claims asserted in the application filed by a relator is such that the claims are not cognizable under Article 1107, Section 3, or stating that the realtor has not filed an application for habeas in Harris County. This application for leave to file writ of mandamus shall be held in abeyance, which means like they're going to put it in limbo until respondent has submitted the appropriate response. Such response shall be submitted within 30 days of the date of this order, September 20th, 2006. And if you remember, I filed the writ way long ago, and it just sat there and sat there and sat there because it was probably on a shelf or in a drawer or a place other than the file in which it belonged. You think? Do you think? I wonder if I have that pulled up anywhere. What can I do for you? Do you not know how to talk? Your parents raised you much better than that, didn't they? Oh my God. Hey, go give that guy next to you a hand job. All right. I just love it when those grifters call. So I don't have that pulled up. I keep looking at that white. That's so bright. I need to put, that's what I need to do. Kill that thing. That's just nailing me. Oh, yeah, that's much better. Whew. Oh, yeah. All right. God, I can half-ass see now. Okay. Motion received. Motion received. Oh, God. 112 motions received. I don't even know what these motions are. Let's go look. When you file a motion, they treat it as a mandamus, motion to compel. Petitioner's motion to compel the 351st Judicial District Court reporter of Harris County, Texas, to transcribe and provide petitioner the complete transcription of the minutes of the motion hearings of March 3rd and March 29th of 2006. So I wasn't able to attend the hearings, and they just had these little, that's what they like to do. They have ex parte hearings where they just do what they want when they want. They don't care. And you see, I have to start giving them directions on the side of the instruments. Tell them whose copy was who. I'm sure this is the 12 motions. Yep, here they are. And we went through we talked about all these, court of inquiry and all that. So there are the motions. They did get it to the court. So I don't have to go through all 12 of those. I hope to show you. We are at 05. Miscellaneous document received. What is this? Original writ of mandamus. Petitioner's appendix. Oh, please, please, please be what I hope you are. Oh, thank God. Oh, shit, I can't believe I have all this. I thought this was lost. Oh, yes. No way. Oh, beautiful. Beautiful, 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 beautiful. Come on, have J. Will Heights notes in here. Hey, what was Floyd doing in 2005? You want to see what I was doing in 2005? Like I said, I forgot more law than most people know in their entire career. Here, this is what I was digging for in 2005, folks. What does it say right here? February 8, 2005, letter to the 351st District Court requesting visiting trial judge Larry L. Fuller's order of assignment, affirmation oath, and anti-bribery oath for May 2002. Huh? Floyd, you were asking for oaths of office back in 2005? Oh, you beast. And who was I requesting it from? The Third Administrative Judicial Reading, presiding judge, B.B. Schraub. Now it's Underwood, Owen Underwood. Oh, yeah. I'm going to go back and revisit most of this. Man, look at all this material. Oh, God. Holy batshit, Robin. Oh, yes, all this is in there. Oh, yes. Come on, please have JT Wilhite's notes. You're all from Moran. Oh, yes, I got all this stuff. Oh, come on, come on, come on, come on. Oh, shit. Reset forms too. Oh, ho, ho, ho. There it is, folks. Oh, beautiful, beautiful, beautiful. I'm going to show you all the notes that my trial attorney did preparing for my case. Oh, I even got the man. Look at all this info. Just 590 pages. All of them have an exhibit number. There's 271 exhibits. All right. And this is actually a map. Okay. That's where I was at. This is where I lived. And literally, there's a bayou that meanders over here, kind of like that. And I could have walked that bayou, but instead I drove, and that's about where he popped me. This is where I was pulled over, seen her arrest. And I literally could have walked home. This is ALR shit. Oh, yes, I'm glad I have all this. This is my timeline. And of course, I didn't understand DWI law, so I thought I was challenging the BAC. And there's our tab. And the bartenders were supposed to come testify. They didn't. My witness affidavits. And this is when I told y'all I was selling hot pre-owned luxury vehicles. And I just started this account because the owner, I worked for him before and made a shit ton of money, had a blast, but I got burned out on it because we did it for a year straight. I mean, just, we could not get enough cars on eBay fast enough to sell them all. It's like everything we put up there is sold immediately. So there's some of the cars that I was selling at that time. This Plymouth Prowler was purple and had 19 miles on it. So it's brand spricken new. This is HTML, all the coding that I had to do for each one. This is what all I was doing before I went and had a couple drinks with somebody. Oh, this is in here. Jesus Christ. I thought all this was just lost forever because I couldn't get the court to reply to me whether they received it or not. And they were accusing me of drinking at home. I'm like, really? You got to do all this shit and you're going to be drunk doing that? Well, you got to be a good drunk to do that, right? Oh yeah, here's my this police officer's report. Oh yes, 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 yes. I don't have to go grab this now. I got it. You can't get this from the police department anymore. So yeah, let's look at this real quick. Offered breath test. Given none. Refusal submitted yes. 0 BAC. See, they already knew I had prior convictions, 2 prior convictions, so they knew I was an easy mark. All they had to do was just lie and get a conviction for a DWI, a felony. Put another notch in their belt. That's how they looked at that. So, liquor found in vehicle, no. Another passenger, no. All I was doing was speeding. Field sobriety test. HGN, horizontal gaze nystagmus test. What's that say? Refused. One leg stand. Refused. Walk and turn. Refused. Well, Mr. Tarvin, since you decided you weren't going to take any tests, I'm going to have to take you into custody on suspicion of driving while intoxicated. Okay, let's do that. I'm going to make you prove I was intoxicated. Let's go to jail. That's exactly what I did. Now, here's my DIC 24, your statutory warning. Now, okay, see, green did all this at the scene of arrest. Okay, this is my traffic report. And you see it's not sworn or anything like that. So these aren't sworn statements. And Nielsen right here, that's the idiot who did a misdemeanor charge. Statutory warning. I'm now requesting a specimen of your breath. Subject refused to allow taking of a specimen as evidenced by his or her signature below. Russell Rudy. Okay? So this is the breath test. He's asking me at Central Intox, downtown, 61 Reason Street. Okay, at about, I don't know, it's probably 2:30, 2:45 in the morning by the time we're doing this. So I refuse them at the scene. I refuse the standardized field sobriety test. I'm here signing documents. I refuse all tests. I'm on video. So he says, met at Central Intox at 2:29. Okay. Now you see what my copy has on it, right? His copy has all these little notes down here that I took the HGN test. So here's the DIC 24, DIC 24. Yeah, here's all his little notes about the HGN that I allegedly took that I didn't. Even sign it on a piece of paper where I refuse tests. I mean, how ironic is that? Does that make any kind of sense, folks? And here's why it takes the time to read this. So nothing's making sense. This is Tricker's notes. Internal affairs complaint on Rudy for violating my rights. And he did do that. You see all his notes. The triangle stands for defendant, in case you didn't know. That's lawyer shorthand. my criminal record. This is my ALR hearing. If you get a DWI, go have an ALR hearing. That's where your administrative license revocation hearing. Make sure it's the same attorney. Go be present so you can have your attorney ask the correct questions. Make sure you understand everything that you're doing before you go in there. You need to know more than your attorney does if you have an attorney. I would, and you see Doug Murphy right here. Well, guess who Doug Murphy works for or with? He partnered up with Troy McKinney. That would be of the former Schneider and McKinney. Where did we hear that before? That would be my court-appointed appeal attorney, Tom Moran, who worked for, I don't know if he still does, for Schneider and McKinney. Doug Murphy worked for Trichter and Samuelson, and then it was Trichter and Murphy, and then Trichter and a couple other people. He's the one who conducted my ALR hearing. I was not present. Hindsight, I made a major mistake because there were things that should have been asked that weren't asked in this particular hearing. And this is a sworn hearing, so everybody's under oath. And this is your impeachment evidence you can use at trial to impeach the prior testimony of your witnesses or state's witnesses. So this one, talk about the DIC 23, 24, 25. And Officer Rudy was subpoenaed, and he did not show up. Wonder why? He didn't show up because he lied, and he knew he was going to have to testify under oath. Green, he's testifying to a police report that's not under oath. So this is quite lengthy. Grab that tab. There we go. Let's go down here. Where were we at with Ding Dong? See how close we got. As I speak, Schneider and McKinney, Tom Moran. Oh, I was pissed. PDR. Dear Mr. Tarvin, I completely turned in the report record for your case. This Jacqueline Fagan, she was their court reporter. You see, some of them, they're like really, people who have some type of integrity. And they do the right thing when they're supposed to do the right thing. Oh, reset forms. Right, let me show y'all something else real quick. You see, state offer 25 years TDC. That was December 4th. Let me show y'all how ridiculous this got real quick. Last to hire attorney. It's April. I got this in July, so we're into what, August? August, yeah. I'd hired Trichter. I think I got all this from Trichter. They offered me a 10, and I sent Gary back to ask for 7, and they refused the 7. They said 10. If I don't take the 10, it's 15 next time I walk in the door. So I had to take 10 years that day, which I should have. Should have jumped all over that. in hindsight, but I didn't. But I'm not fucked up about it one iota because it is what it is. 25 years TDC. Motion to hire attorney. We had 9/11 happen, and my job, we couldn't get any more money imported from overseas, and I was broke. And I don't know, that's a picture, mugshot, notice of appeal, new trial, another mugshot. Oh, these are all pictures of the scene. Subpoenas. These are Gary's notes. Gary Trichter. Okay, I remembered all this. This is Gary's file. I asked Gary. Gary sent my file to Will Height. I asked Will Height to send me my file. He sent it. This is it. Y'all may not remember Kevin Fine, but he was a defense attorney and he was challenging the constitutionality, specific statutes. Eventually ran for judge. And then when he got into the judgeship, he lasted one term. They shut him down. And that's my PSI. We can get through quickly. I'm looking for something. I'm gonna have to print all this out and figure out where the hell it is to go find it. It'll take me forever doing it this way. Somebody had to go back and renumber all these. As you can tell, they were very fond of me. Oh shit, that dude's back again. All right, yeah, here we go. Back to where I started. Come on, what's that? Yeah, me and Tom Moran were going round and round of the bullshit little freaking appeal brief he filed. I was appalled. I'm like, bro, there's jurisdictional defects. There's jurisdictional defects. Why aren't you challenging jurisdictional defects? What are you doing? The Supreme Court just ruled on this not a month ago. And that's what you're challenging? Come on, man. Withdraw this shit. Refile it. God, I gotta reread all this stuff. Fuck. I don't know why that was blacked out. Oh, let's go into the record. Let's see. Let me go look. At the beginning. Okay, it's after that. After all that. A248. My bad. That's me numbering them. Three, 250. Oh, yeah. Oh, passed right over them. This page and this page. Those are his notes. That's his entire trial preparation right there. 2 pages. That's it. Everything else belonged to Trichter. Oh, man. Wow. I agree with you. But until, they comprehend that, nothing's going to change. It's going to stay the same. Oh, no. Charlie Kirk is passed away. He's deceased. Wow. Well, he will become a martyr. What a crazy world we live in, huh? Anybody have any questions about what I've shown you? And I just, man, we haven't even We haven't even got to the good shit. We're at 5. We've got 6 more to go. Imagine what that looks like. I don't want to keep you here all day. I just want to go through some of that stuff with you. Let me. Man, that's going to be an arduous task. If I remember where I did with those. And exhibits. Nope. What did I do with them? Can't remember where I filed the files. Maybe there. No, close. I don't think it's in there. Nope. I doubt it's in there, but it may be. Nope. Huh. And I don't know what I labeled it. Let me try. I was going to do a show about it. Nope. I'll have to find it. There you go. Oh, here's, let me share my screen. Sorry. Dirt. Here you go. This is my finding of fact, conclusions of law, written by the pothead, allegedly, Judge J. Carahan, Harris County Criminal Court at Law number 8. And this says, the trial court judicially notices the fact that between 2004 and 2006, documents filed with the district clerk's office in the county criminal courts at law were routinely found stuffed in drawers, on shelves, or places other than in the file of the case in which they belonged. Some were file marked, some bore no official file mark. I don't know what the extra word is, but that's it. That's from Judge J. Carahan. There it is in black and white, filed into my record. No accountability. These people have free reign to be some of the most prolific criminals, anti-constitutionalists in the history of the world. It's insane what they'll do. So there's just a little brief scintilla of some of the insanity crazy world. Can't wait to redo my writ and back it up with now all this recovered evidence. I don't even know how to put all that together now. I didn't even get to my brief. Y'all want to go look at my brief real quick? Those 95 grounds of error. Let me take you on a quick journey over there. And 10. Is this it? Received. Jesus Christ. 709 page. Oh, God. 841 pages? Holy moly. Did I just say holy moly? $841 pages. Let's just go back to the beginning and start there. February 24th, 2010. Y'all remember when I originally filed this? Yeah, way back then. Action taken. Remanded for evidentiary hearing. I don't know which judge signed that. There's the bench warrant request for the habeas corpus. These are all the motions. By now, I'd already been locked up 8 years. I'm already up for parole. I think I already had a set off. And now I'm getting jaded because I see that they're not going to let me win no matter what I do. I got a lot of reading to do. Here's the application. So here's A, ground one. And then this is where you start having to do your own forms. And here we go. Errors, capital D through lowercase qq, 95. I don't know why it says 595. So basically, I just came back, filed the same petition again, only this round I did not have all the exhibits to go with it. This is just the application, folks, that I'm going through right here. 31, 32, 33, 34, 35, 36, 37, 38, 39, 40. Again, this is just the application. I left no stone unturned. I would say probably a third of these you can wash out as redundant. But I wanted to address them as each individual error. I didn't want to lump them all into one error where the court can just outright address that one blanket error and then cover all of them. And then, you know, I could have had a winner in there and they just, you know, didn't want to pay attention. See, here's the guidelines. State 15 days in which to answer the application after having been served. If after the 15 days allowed the state to answer the application, the court has 20 days. Obviously, nobody wants to hold anybody accountable because I'm complaining back and forth, having to go through all this bullshit. This is where he granted my motions. Some he granted, some he denied. Some he didn't even rule upon. Now, this is them blacking this out. I don't know why they're blacking this information out. I got several pieces that are blacked out like that. See what I mean? And this is my certificate of service. So somebody's address they don't want me to see here. And I don't know. I'll figure it out eventually. I may have the same document with that information on it somewhere in another file. No telling. Okay, that was received. Get back here to this one. Well, that's my remand order. Yep, the hearing that they didn't refuse to have. And it's just a brief. Oh, yeah. Come on, join the insanity. Get ready for a trip on the magical mystery tour. Step right this way. Ta-da! The magical mystery tour is coming to take you away. Coming to take you today. And here we go. Page 1. Court's copy. Page 2. Make sure we know who all the parties are, because it's a party. Table of contents. Again, this is back when I was still a little fancy. Page 3. Here's my grounds of error. All 95 of them. Yes, sir. I told you. 300-page brief. Add the application. It was 400 plus pages. You throw in the appendix of exhibits. Uh-oh, you're looking at almost 1,000 pages. All organized. All cases in alphabetical order. And you better bet when you go to page 227, you're going to see this case cited. Absolutely. Now, I didn't have a computer. This is all done with an electric typewriter. Looking at this, since I don't see very many typing errors, this was probably done when I had a word processor, Smith Corona, but it only held maybe one line of text. Another one held maybe about 3 paragraphs. And in 14 years of incarceration, I went through over 30, you heard me, 30 typewriters. And finalizing the Texas Court of Appeals cases. Now we're getting into the Court of Criminal Appeals cases. So all these cases you see, I had to go read them. Now we're Texas Supreme Court. And this should be the U.S. District Courts. Circuit Court of Appeals. It's supposed to be Fifth Circuit and other circuits. And we're getting ready to roll into the United States Supreme Court. When we get through all these circuit courts of appeals, I know, doesn't this look fun organizing all this? Code of Criminal Procedures articles, Federal Code of Criminal Procedure, Texas Government Codes, Texas Penal Code, Texas Transportation Code, Rules of Appellate Procedure, Rules of Civil Procedure, Texas Rules of Evidence, Texas Constitution, United States Constitution, other legal jurisdictions, United States, other legal jurisdictions, United States. Now, none of these have any authority, period. Okay. What I did, though, is use them as examples. That's how that works. Here's your other publications from American Heritage Dictionary of the English Language, Black's Law, Code of Judicial Conduct, commentaries, blah, 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 blah. Lower court opinions. Statement of the case. Grounds for relief. Here's ground one. There's your ground. Here's your harm and prejudice. Here's your standard of review. Here are the facts. Relief requested. Ground two. And this is how I broke this thing down all the way through every freaking ground. All 95 of them. Let's see where we're at here. I'm back. Lost all my viewers. So, yeah, I don't know what happened over here. This computer froze up. Thank you, StreamYard, for snagging all my bandwidth. So anyway, thank you for hanging out. I'm going to close out and go dig into this. Have a great day. Thanks for watching. Thank you for hanging around after the show. I want to present to you Tailor-Made Trust, featuring Ann LaFleur's Trust Series, available at tailormadetrust.com, as well as the fearlessfloydshow.com store. Here are a handful of the available trusts that can be built, custom tailored to your needs and desires. 25 different trusts, plus the DNA trust addendum. And as always, Ann LaFleur's classic trusts and ancillary classes, and also Ann's books on trust and specialty trust, which I also co-authored. If you'd like to get a class, a book, or have a trust custom built for you, always available at the fearlessfloydshow.com store. And I'll see you in the next show. Thank you for watching and have an awesome day.